Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 2nd to 6th, and today is April 9th, 2018. A United States appeals court said that the Commodity Exchange Act's prohibition against spoofing and other conduct could potentially apply in connection with a lawsuit against a U.S.-based trading firm brought by 5 Korean residents related to transactions involving the Kospi 200 futures contract on the Korean exchange's night market. This was because of the KRX's use of the Chicago Mercantile Exchange's Globex platform to match transactions. However, this was despite no Kospi 200 futures contract settling until the next day in Korea through the KRX clearinghouse. Separately, defendants in an anti-fraud enforcement action related to virtual currencies brought by the Commodity Futures Trading Commission first objected to the Commission's jurisdiction and then consented to the agency's entry of a preliminary injunction without prejudice to their right to assert their jurisdictional claim in later arguments. Last week we had unexpected snow in New York City, so I might try to enjoy what seems to be shaping up as the first spring-like temperatures week of spring this year. Let's get started. The U.S. Court of Appeals in New York held that Tower Research Capital must stand trial in connection with an amended complaint filed by 5 Korean citizens alleging that the firm and its founder, Mark Gorton, engaged in spoofing-type conduct in Kospi 200 stock index futures contracts cleared and settled on the Korean exchange in violation of U.S. law and New York's prohibition on unjust enrichment. Last year, a federal district court in New York dismissed plaintiffs' action, holding that application of the relevant law, the Commodity Exchange Act, would constitute an, quote, impermissible extraterritorial application, end of quote, and that plaintiffs had no evidence of a direct relationship with defendants necessary to sustain a claim of unjust enrichment. The appellate court reversed this decision. According to plaintiffs, who filed this action as a class action, the defendants engaged in spoofing-type conduct from January 1st through December 31st, 2012, to manipulate the price of Kospi futures for defendants' own benefit to the detriment of plaintiffs. Each of the relevant transactions was executed on the KRX night market when the KRX was closed for business. During this time, KRX members or traders authorized by such members entered orders that were matched with anonymous counterparties through the Chicago Mercantile Exchange's Globex electronic trading platform. These trades then cleared and settled on the KRX the next morning after the KRX opened. Relying on a 2010 Supreme Court decision, the District Court held that for future transactions to be subject to the Commodity Exchange Act, parties to such transactions must, quote, incur irrevocable liability, end of quote, in the U.S. or on a U.S. exchange. However, the District Court ruled that this was not the case for transactions executed during the KRX night market because trades there were only final when they were cleared and settled on KRX the next day, and not at the moment they were matched on CMX Globex. Moreover, held the District Court, plaintiffs failed to sufficiently allege that CME Globex was a quote-unquote domestic exchange, as it is not distinctly registered as an exchange with the Commodity Futures Trading Commission, like CME itself. The appellate court reversed the District Court, however, because in its views, there were quote-unquote plausible allegation that parties to KRX night market transactions incurred irrevocable liability in the U.S., and this was sufficient basis for plaintiffs to invoke the Commodity Exchange Act and avoid defendants' motion to dismiss. This is because, said the appellate court, plaintiffs sufficiently argued that KRX night market trades, quote, bind the parties on matching, end of quote. To me, this seems like an extensive reach for the application of U.S. law and doesn't quite get the facts right. Check out my views at www.bridgingtheweek.com. On March 30th, My Bitcoin Pay, Inc., Randall Carter, and Mark Gillespie claimed that the CFTC lacked authority to bring an enforcement action against them, charging fraud in connection with the offer of a virtual currency token because the digital token was not a commodity under applicable law, the Commodity Exchange Act, and thus the Commission lacked jurisdiction. However, without prejudice to this argument, subsequently on April 5th, the defendants consented to imposition of a preliminary injunction against them. In January, the CFTC filed an enforcement action against the defendants for allegedly engaging in a virtual currency scheme that misappropriated approximately $6 million from 28 or more persons from at least January 2014 through January 2018. The defendants filed a motion to dismiss the CFTC's complaint, claiming that it lacked jurisdiction under applicable law. According to the defendants, the CFTC may only bring an enforcement action alleging fraud in connection with the offer and sale of a commodity transacted in interstate commerce. However, to the defendants, their virtual currency, named My Bitcoin, was not a commodity as defined in applicable law because it was not one of the specifically enumerated 26 commodities in the Commodity Exchange Act's definition, and it was not a service, right, or interest, quote, in which contracts for future delivery are presently or in the future dealt in, end of quote. According to the defendants, only Bitcoin qualifies as a commodity as there are currently futures contracts trading based on that virtual currency. However, days after filing a memorandum of law in support of their motion, defendants consented to the imposition of a preliminary injunction and other relief, although they conceded jurisdiction and venue solely, quote, for the limited purposes, end of quote, of the court order. In my view, the defendants take a too narrow view of what is a commodity under the Commodity Exchange Act. See what I think on www.bridgingtheweek.com. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. And you know where it is. Check it out. I'm Gary DeWaal. Have a great week. And until the next edition of Bridging the Week, ciao.